Okay, let's unpack this. Have you ever really stopped to consider what makes someone a citizen of a nation?
It's a fundamental question, isn't it?
Especially, for a place as incredibly diverse and complex as India, right at its very genesis.
Absolutely.
It's far more than just, where you happen to be born. It's really a foundational question about identity, isn't it? About belonging.
And ultimately, about the very fabric, the future of a country.
Yeah.
Yeah.
So today we're taking a deep dive into the absolute bedrock of Indian citizenship, specifically how it was meticulously laid out in the Constitution.
Right. Part-2, Articles 5 through 11.
Exactly. And these articles, they weren't just drafted in some quiet committee room, were they?
No, far from it.
They were crafted at such a pivotal, often tumultuous moment in history.
Right after independence from colonial rule, and crucially in the wake of the devastating partition of the subcontinent. A really challenging time.
Yeah, they literally set the stage for who would belong to this brand new sovereign nation.
And what's truly fascinating here, I think, is how these initial constitutional provisions, they weren't just a snapshot.
Yeah.
Defining who was a citizen for that specific moment in 1950.
So it was more than just that.
Oh, definitely. They also established this remarkably dynamic and adaptable framework for the future evolution of citizenship laws in India.
Okay.
So we're going to explore the immediate pressing challenges of independence and partition that these articles were specifically designed to address.
Makes sense.
We'll then carefully unpack the core principles, the sort of intricate pathways, and the occasional exceptions embedded within each one.
Right.
And finally, we'll see how they collectively empower India's parliament to shape citizenship laws even today, adapting to new realities, new challenges.
So the goal for you listening is?
Well, our ultimate goal is that you walk away with a really crystal clear understanding of the profound historical context, the subtle but powerful legal nuances.
And the so what, basically.
Exactly. The so what of India's foundational approach to citizenship. It's a story of national identity being forged in fire, really.
Okay, so before we zoom in specifically on citizenship itself, it's probably crucial to understand the broader constitutional vision, right? What India's founders were aiming for overall.
Absolutely. Context is key.
And the sources we've explored, they really highlight that this wasn't just some haphazard collection of rules thrown together.
No.
They articulated a really profound aspirational philosophy right from the get-go.
Exactly. And you can see this vision starting right with the preamble itself.
The introduction, yeah.
But it's more than just an intro. It acts almost like the guiding star for the entire Constitution.
Yeah.
Articulating the nation's vision, its core philosophy.
Setting the tone.
It set the moral and political tone for everything that follows, including, of course, the very concept of who an Indian citizen is.
Right.
It talks about justice, liberty, equality, fraternity. These huge ideals that underpin the entire legal structure. And then you move to Article 1. This lays down the fundamental definition of India itself, a union of states.
Okay.
And it meticulously outlines its territory. Now, this might seem like a mere technicality, right?
Yeah.
Defining the map.
Yeah, just geography.
But it's absolutely crucial because when we talk about citizenship, we need to know what territory of India actually refers to at any given time.
Okay. The physical space.
Exactly. This initial article provides the concrete geographical and political boundaries. That's the container within which all subsequent citizenship provisions operate. It gives a tangible reference point for belonging.
And here's where, for me, it starts to get really interesting. Articles 2 and 3.
Ah, yes, the flexibility.
They grant Parliament truly incredible power. Almost like map-making power, you could say.
That's a good way of it.
Article 2 lets Parliament admit or establish new states, so incorporating new territories into the Union.
Right. Expansion.
And Article 3 empowers it to reorganize existing states, changing boundaries, creating new states from old ones, even altering their name.
Huge powers.
And the real kicker, I think, is Article 4, which makes this whole process procedurally simple.
Yeah, just ordinary legislation.
Right, not a complex constitutional amendment every time you want to change a state boundary.
Which immediately raises a big question, doesn't it?
Yeah.
Why? Why build in such an emphasis on territorial flexibility right from the very beginning?
Good point. What was the thinking?
Well, I think the framers knew India was this subcontinent of immense diversity, of vast land, shifting demographics, regional aspirations, evolving political needs.
A lot to manage.
A huge amount. So this design choice, it really underscores India's unique blend of federalism and unitary strength.
Okay.
They wanted the inherent ability to adapt the nation's physical and political boundaries without needing to fundamentally alter the constitutional blueprint every single time.
That sounds like foresight.
It absolutely was.
Yeah.
This foresight means the territory of India wasn't ever envisioned as static. It's a living, breathing entity capable of expansion, internal reorganization.
And that dynamic nature, it must directly impact citizenship, right?
Precisely. It directly impacts who might qualify as a citizen in a shifting landscape, especially if new territories are incorporated or even if existing internal boundaries are redefined.
Wow.
It's a profound statement, really, about the adaptability baked into the very first pages of India's foundational legal document.
So with that stage set defining the very contours of the nation, this potentially shifting territory, let's now dive into Article 5.
The starting point for citizenship itself.
Exactly. This article basically drew the first major line in the sand. It stipulated precisely who was considered an Indian citizen on that specific day. January 26, 1950.
The day the Constitution came into force.
Right. This was the foundational moment determining the initial sort of automatic pool of citizens for the brand new republic.
Yeah, creating that immediate sense of belonging for those who were already fundamentally within India's newly defined boundaries.
So what was the core concept here? How did it work?
Well, the core concept of Article 5 is really about defining who is automatically deemed a citizen right at the commencement of the Constitution.
Automatically.
Okay. And it's built on a cornerstone principle, domicile. That's the key word, combined with other specific conditions, like birth within India or long-term residence.
So domicile plus something else.
Exactly. Think of it as an initial, quite inclusive sweep, designed to embrace the vast majority of people who already genuinely considered India their permanent home, establishing their legal relationship with the new state from day one.
Okay, so let's unpack those ingredients. You needed domicile in India. That was mandatory.
Absolutely mandatory.
And then on top of that, you needed at least one of three other specific conditions.
Right.
So let's start with that mandatory prerequisite domicile in India. What exactly did that mean? Because it sounds a bit more than just living there.
It is. That's a crucial distinction. Domicile isn't simply about where you happen to be physically living at a given moment. It's about your permanent home.
Permanent home, okay.
Coupled with a clear, unequivocal intention to reside there indefinitely. Lawyers often call this animus munendi, the intention to remain.
The intention matters.
Hugely. It signifies a much deeper connection than just temporary residence. And this was critical. For instance, there was a landmark case, D.P. Joshi versus State of Madhya Pradesh.
Okay.
And the Supreme Court clarified that citizenship is primarily a political status, your relationship with the state, whereas domicile is a civil concept relating to your permanent home for legal purposes like marriage, inheritance, etc.
Interesting distinction.
Very. And you could, in theory, be domiciled somewhere without being a citizen, or vice versa. But for Article 5, domicile in India was absolutely mandatory. It meant a settled, fixed habitation, implying a long-term, genuine commitment to India as your home.
Not just passing through.
Not just passing through. And another vital clarification came from Pradeep Jain versus Union of India.
What did that establish?
It established that for citizenship purposes, India has only one domicile, the domicile of India as a whole.
Not state domiciles, like domicile of Bengal or domicile of Punjab.
Exactly. No separate state domiciles for this purpose. This was paramount for preventing any fragmentation of loyalty along internal state lines. It reinforced the idea of a single unified Indian identity right from the start.
That makes a lot of sense.
And importantly, another case, Mohammed Raza versus State of Bombay, emphasized that just saying you intended to reside wasn't enough.
Actions speak louder than words.
Pretty much. Actual demonstrable residence in India, consistent with that intention, was key. You had to physically establish your life there, make it your home, providing a tangible, verifiable link to the new nation.
Okay, so domicile, established, permanent home, intention to stay, actual residence. Then you needed one of the additional conditions.
Correct, just one.
The first pathway was if you were born within the territory of India.
Right. This aligns with the principle often known as jus soli.
The right of soil.
Exactly, the right of soil. So, for example, if you were domiciled in Delhi on Jan 26, 1950, and you happen to have been born in Mumbai, both clearly within the territory of India,
You're in.
you'd automatically qualify as a citizen under Article 5A. Pretty straightforward, a very direct link. Citizenship based on place of birth within the new nation's territory.
Okay, that's path one. What was the second?
The second pathway broadened the net quite a bit. It was if either of your parents was born in the territory of India.
Ah, so looking at the previous generation.
Yes. This brings in an element of what we call jus sanguinis, the right of blood.
Right, of blood, okay.
So imagine an individual domiciled in India. Maybe they themselves were born just outside the new Indian borders, perhaps during a family trip or something.
Okay.
But one of their parents, mother or father, had been born in a part of pre-partition India that subsequently became part of the current Indian territory.
Then they qualify.
Yes, under Article 5B.
Mm-hmm.
This provision was really essential for capturing those whose immediate lineage, their parentage, was deeply connected to the land that ultimately formed modern India, even if their own specific birthplace happened to be elsewhere.
It acknowledges those strong family ties to the land.
Precisely. It established a powerful claim to belonging, even if you weren't physically born in the exact territory of the new India.
Makes sense. And the third condition?
The third one was based on residence over time. If you had been ordinarily resident in India for at least 5 years, immediately preceding January 26, 1950.
5 years straight before the Constitution started.
Yes, immediately preceding. This was a very pragmatic and encompassing provision.
How so?
Well, picture a person domiciled in India, genuinely intending to make it their permanent home. Maybe they weren't born there, and maybe neither of their parents were born in what became India.
Okay.
But they had been living continuously in India since, say, 1940. That's well over 5 years before the Constitution's commencement date.
Right.
Such an individual would unequivocally qualify under Article 5C. This pathway was absolutely vital for people who had, over time, adopted India as their home, even if their direct birth or immediate lineage wasn't tied to the defined territory.
So it captured people who had genuinely integrated.
Exactly. Those who had genuinely integrated into the nascent nation society contributed to its life for a substantial period. It recognized lived experience and commitment.
So this overall approach in Article 5 with these multiple grounds, it seems very inclusive.
It was deliberately designed to be inclusive as a crucial decision by the framers. The goal was to ensure that the vast majority of people who already considered India their home, especially given the trauma of independence and partition, were recognized as citizens without facing unnecessary hurdles.
Creating a broad base.
Exactly. Creating a broad, stable foundation for the new nation's populace, making sure citizenship wasn't overly exclusive, but rather embraced those with clear, established ties, whether by birth, parentage, or sustained genuine residence.
It sounds like a very pragmatic, but also quite compassionate response to a really chaotic time.
I think that's fair to say, especially considering the heartbreaking aftermath of independence and partition.
Okay, so if Article 5 was about casting that broad net for those already within India's new borders, Article 6 then dives into one of the most painful, complex realities of that whole era.
Partition.
The partition of India and Pakistan, which led to these massive population shifts, just unimaginable human displacement.
On an unprecedented scale. Horrific.
So Article 6 steps in to deal specifically directly with those who migrated from what became Pakistan to India.
Yes, a very specific group.
And you mentioned this is a special rule. It overrides Article 5.
It operates notwithstanding anything in Article 5. That's the key phrase, meaning it carves out a distinct paramount category for these individuals. It provides an alternative, highly specific path to citizenship just for them.
Why was that necessary? Why not just use Article 5?
Well, it was a clear recognition that the standard domicile rules of Article 5, while inclusive, simply wouldn't adequately address the immense human flood. We're talking millions uprooted by partition, seeking a new home in India.
Right. A unique situation needing a unique rule.
Exactly. And this article, Article 6, specifically focuses on establishing an ancestral connection, not just to the new India, but to India as defined in the Government of India Act, 1935, as originally enacted.
So pre-partition British India?
Precisely. That refers to the territory of British India before partition. This was crucial. It ensured that only those with a pre-existing ancestral link to the broader Indian subcontinent could claim this special migration pathway.
Okay, so to qualify under Article 6, what did a migrant need? You mentioned 3 things.
Yes, 3 essential elements. First, obviously, they had to have physically migrated from what became Pakistan to India, a demonstrable move across the new border.
Makes sense, check.
Second, they absolutely needed that ancestral connection to undivided India.
The 1935 Act definition again.
Right. He or either of his parents or any of his grandparents must have been born in India as defined in the Government of India Act, 1935, as originally enacted, basically tying them back to the broader Indian subcontinent, demonstrating their Indian origin.
Okay, migration and ancestry. What is the third?
The third element was truly crucial, and it involved a specific date, July 19th, 1948.
July 19th, 1948. Why that date?
It's historically significant. It was the date when a formal permit system for migration was officially introduced between the two new dominions, India and Pakistan.
A permit system. Okay.
Yes. And this permit system marked a significant shift in how migration between the two countries was viewed and, importantly, controlled.
So did it matter if you migrated before or after this date?
It mattered hugely. The rules were different.
Okay, let's take the before group first. Migration before July 19th, 1948.
For those who migrated before that pivotal date, the process was relatively simpler. They were automatically deemed a citizen if they had been ordinarily resident in India since their migration.
So move, stay, you're a citizen.
Largely, yes. The act of moving and establishing residence, demonstrating that clear intent to settle, was generally considered sufficient.
Let me give an example.
Sure. Let's imagine someone whose grandparents were born in pre-partition British India. This individual migrates from Karachi to Bombay in, say, January 1948, well before the cutoff date.
Okay.
And they've been living there continuously since. This person would automatically be a citizen under this provision. Their early movement, their continuous residence, show their intent to be part of the new India.
Got it. But what about those who migrated on or after July 19th, 1948? when the permit system was in place.
This is where it changed. For these later arrivals, it introduced a new, more formal step.
More paperwork.
Essentially, yes, they were required to be registered as a citizen by an appointed officer.
Registered. Okay, not automatic.
Not automatic. And crucially, this registration had to happen before the Constitution's commencement on January 26, 1950.
A deadline.
A deadline, yes. And there was another prerequisite. They needed to have been ordinarily resident in India for at least 6 months immediately preceding their application for registration.
So live here for 6 months, then apply to be registered all before Jan 26, 1950.
Exactly. It introduced a layer of formality and required a demonstration of sustained commitment for those arriving after the permit system began.
Can you illustrate that?
Okay. Imagine someone with ancestral ties to British India migrates from Lahore to Delhi in August 1948. That's after the cutoff date.
Right.
They wouldn't automatically be a citizen. Instead, they needed to live in India for at least 6 months, then proactively apply for registration with a designated officer, and critically, be successfully registered before January 26, 1950.
So the later you arrived, the more proactive you had to be.
Precisely. To formally establish your claim to citizenship.
Now, this idea of migration itself seems key. Did the courts have to define what that meant?
They did. It immediately raised an important question. What exactly constitutes migration in this context? Is just crossing the border enough?
Yeah.
The Supreme Court, in significant cases like Shano Devi versus Mangal Sain, and also Kulathil Mamu versus State of Kerala, provided vital clarification.
And what did they say?
They stated that migration, for the purpose of Article 6, meant coming to India with the clear intention of residing permanently.
Intention again, like with the domicile.
Exactly. A mere temporary visit, even if it lasted for some time, wouldn't qualify under Article 6. It highlights that it wasn't just about physically crossing a border. It was about a conscious, volitional act of seeking a new, permanent home and aligning one's future with India.
That makes sense.
And legally, this whole structure, Article 6 overriding Article 5 for this specific group, is a classic example of a legal principle. Lex specialis derogat legi generali.
Latin. What does that mean?
It means a special law overrides a general law. Article 6, being specific to the unique circumstances of partition migrants, was given precedence over the more general conditions of Article 5 for this particular group.
A tailored solution.
A tailored solution. It really demonstrates the constitutional framers' foresight and their intent to provide a compassionate yet controlled solution for an absolutely unprecedented historical challenge.
Okay, so Article 6 covered those coming to India from Pakistan. What about the other side of that coin? People who initially left India for Pakistan.
Yes, Article 7. This addresses that incredibly sensitive and complex situation.
And you mentioned this one has an even stronger overriding effect.
It does. It states explicitly, notwithstanding anything in Articles 5 and 6.
Both 5 and 6. Wow.
Yes, this implies a really clear and powerful intent to generally cut off citizenship for those who chose to leave India for Pakistan, even if they might have initially met the broad conditions of Article 5 or even the migrant conditions of Article 6.
So leaving was seen as a pretty definitive act.
Generally, yes. Reflecting the gravity of that choice during such a period of national upheaval, Article 7 largely acts as a disqualification. Its core principle is, if you generally log your claim to Indian citizenship.
Even if you were born in India, domiciled here.
Even then. However, and this is a truly critical proviso, a sort of vital safety valve. An exception, yes. There's an explicit return path provided. For those who might have regretted their decision, or maybe whose circumstances fundamentally changed, it shows the framers understood the deeply human dilemmas caught up in the chaos of partition.
Okay, so what was that disqualification trigger? The date?
The key date here is March 1st, 1947.
March 1st, 1947. That's quite early, even before independence or partition were formally announced.
It is. If someone migrated from India to Pakistan after this date, they were generally not considered an Indian citizen at the commencement of the Constitution.
Why that specific date?
Well, historians point to it roughly marking the significant escalation of widespread communal disturbances and the beginning of those large-scale mass population movements that tragically preceded the formal partition announcement and independence later that year.
So it was seen as a point of no return, in a way.
Or at least a point where leaving India likely signified a strong intent, perhaps born of fear or desperation, to permanently relocate to what was anticipated to become Pakistan.
So an example.
Okay. Imagine a person born and domiciled in India, clearly meeting the Article 5 criteria. But then they chose to move to Pakistan in, say, April 1947 after March 1st.
Right.
Under Article 7, despite their initial strong ties to India, they would not be an Indian citizen when the Constitution commenced because of that post-March 1st migration.
But you mentioned an exception, a return path.
Yes, and here's where it gets really interesting, showing the nuance. The disqualification under Article 7 didn't apply if such a person later returned to India under a very specific document. a permit for resettlement or permanent return.
Another permit.
Yes, issued by a competent authority. This permit wasn't just a piece of paper, it was absolutely crucial. A formal gateway back into India with the intent to stay.
So if you got this permit and came back, what then? Were you automatically a citizen again?
Not quite automatically. If you did return with such an official permit, you were then treated for legal purposes as if you had migrated to India after July 19th, 1948.
So like the later arrivals under Article 6.
Exactly. Which, as we discussed, meant you typically needed to go through that formal registration process.
The 6 months residence, the application, getting registered before Jan 26, 1950.
Precisely. For these returnees, under the permit, they would usually need to fulfill all the registration requirements outlined back in Article 6b to regain, or maybe more accurately, be deemed to have acquired citizenship.
So another example.
Sure. Someone migrates to Pakistan in May 1947 after the March 1st cutoff. But then maybe they regret it, maybe things change, and they return to India in 1949 under one of these official permanent resettlement permits.
Sure.
They wouldn't just become a citizen on arrival. They would then need to fulfill the Article 6b2 registration requirements, live there 6 months, apply, get registered before the Constitution commenced.
It offered a path back, but a structured official one.
Yes, ensuring a measure of control and deliberate choice on both sides. But it certainly wasn't automatic restoration of citizenship.
And presumably, the definition of migration here also involved intention.
Absolutely. Similar to Article 6, the legal interpretation of migration in Article 7 implies a clear intention to abandon India as one's permanent home and settle definitively in Pakistan.
Was this tested in court?
Yes. The Supreme Court, in cases like State of Andhra Pradesh versus Abdul Qadir, consistently upheld this view. They emphasized that the permit for re-entry was the vital legal instrument. Simply returning without such a valid official permit wouldn't restore citizenship under this article. It signaled a lack of formal approval for a permanent return, reinforcing the idea of a conscious, legally recognized choice to leave India in the first place.
This all highlights how deeply personal and sometimes complicated these situations must have been.
Immensely so.
Yeah.
Imagine a case like the one mentioned in the sources, State of Bihar versus Kumar Anwar Singh. It involved a married woman who had gone to Karachi. The courts, in such instances, had to delve meticulously into the specific facts, the individual circumstances of her case. Was there a true underlying intention to abandon her Indian domicile? Or was her journey to Pakistan merely a temporary visit, maybe for family reasons, without the intent to permanently leave India?
So it wasn't always clear-cut.
Far from it. It highlights the profoundly human and often ambiguous nature of these constitutional definitions. It required careful, compassionate examination of individual intent and circumstance, far beyond just noting the physical movement across a border.
It sounds like Article 7 embodies a kind of choice.
In a profound way, yes. It reflects what legal scholars often refer to as a doctrine of election concerning citizenship.
Doctrine of election.
By choosing to migrate to Pakistan after that specific date, March 1st, 1947, individuals were presumed, by law, to have made a choice effectively electing Pakistani citizenship, unless they formally and legally returned to India under those precisely specified conditions of the permit system.
A presumption based on action.
Exactly. It's a powerful statement about allegiance and the profound consequences of choosing one nation over another during that intense period of national formation and division. The framers really had to grapple with the reality of competing loyalties in a time of unprecedented flux.
Okay, so we've covered those within India's new borders with Article 5. We've covered the migrations between India and Pakistan with Articles 6 and 7. But India's constitutional framers also looked outwards, didn't they?
They did indeed, beyond the immediate turmoil of partition.
And that brings us to Article 8, which deals with persons of Indian origin who were residing outside undivided India when the Constitution commenced.
Yes, diaspora.
And again, this operates notwithstanding anything in Article 5.
Correct. Offering another distinct proactive pathway for those who weren't physically present within India's new borders or directly impacted by the immediate partition migrations. It was a very forward-looking recognition of a global Indian community.
So what was the core concept here, reaching out to Indians abroad?
Essentially, yes. The core concept is deeply significant. It's about allowing individuals of clear Indian origin, even if they were living abroad, to acquire Indian citizenship.
Ooh.
Through a process of registration facilitated by India's diplomatic missions, embassies, consulates around the world.
So applying at the local embassy.
Exactly. It was a remarkably forward-thinking provision for its time, 1950, designed to keep ties with the vast Indian diaspora strong and to provide a clear legal avenue for them to connect with the newly independent nation if they chose to.
It recognized a connection beyond borders.
Absolutely.
Okay.
It unequivocally recognized a historical and cultural connection that could, and perhaps should, translate into formal legal citizenship, acknowledging that India's reach and identity extended far beyond its immediate physical borders. It's a powerful statement about preserving a global Indian family.
So, if you were someone of Indian origin living abroad back then and you wanted to take this path, what did you need?
Okay, a few key requirements. First, crucially demonstrating Indian origin. The person themselves, or either their parents or any of their grandparents, must have been born in India as defined in the Government of India Act, 1935, as originally enacted.
Back to the 1935 Act definition again, pre-partition India.
Yes, establishing that crucial ancestral link. Second, they literally had to be ordinarily residing in any country outside undivided India.
So you couldn't be living in India and use Article 8.
No, this was specifically for those abroad. Third, and this is the key action step, they needed to be formally registered as a citizen.
By whom?
By an Indian diplomatic or consular representative, the official face of India in the country where they were residing. The ambassador, the consul general, their designated officers.
Okay, ancestry, living abroad, registration. Was there anything else?
Well, the registration required a proper application, submitted in the prescribed form and manner. You couldn't just show up and say, make me a citizen.
Formal process.
Formal process.
Yeah.
But what's truly fascinating and shows immense flexibility here is the timing. This registration could occur either before the commencement of the Constitution on January 26, 1950, or even after.
Really? So the window didn't close on Jan 26th?
Not for Article 8 registration. This offered significant ongoing flexibility. It provided a continuing window for the diaspora to formally connect with the newly formed nation, allowing them to make that choice at their own pace, not just in the rush of independence.
That seems quite generous.
It reflects, I think, a deliberate policy to actively foster that sense of continued connection and belonging with the motherland, regardless of geographical location. Its citizenship granted by registration a distinct mechanism from the automatic provisions of Article 5 or the specific migration rules of 6 and 7.
So an example for Article 8.
Okay, imagine a person whose parents were born in, say, Lahore, pre-partition, and this individual was living and working in the UK in 1949.
Right.
They could apply to the Indian High Commission in London to be registered as an Indian citizen under Article 8. Upon successful registration, they would be deemed an Indian citizen.
And they could do this even after Jan 26, 1950.
Yes, that pathway remained open under Article 8. It demonstrates a remarkably long-term vision for diaspora engagement, strengthening those global Indian ties.
So, in legal terms, what principle does this extend?
Well, this provision significantly extends the principle of jus sanguinis citizenship by descent or right of blood. It allows persons of Indian origin living abroad to acquire citizenship not just automatically if they were born on Indian soil, but through a formal, deliberate, administrative act of registration, rooted fundamentally in a shared lineage.
Fascinating. Okay, we've covered how you could become a citizen at commencement. But now let's talk about a principle that seems quite opposite about not being a citizen or losing citizenship. Article 9.
Ah, yes, Article 9, single citizenship.
This seems absolutely fundamental to Indian citizenship right from the beginning. The idea that you can only be a citizen of India, not India and somewhere else.
Absolutely fundamental, and Article 9 makes this unequivocally clear. It leaves no room for ambiguity or dual loyalties.
So what does it actually say?
It explicitly states that if a person voluntarily acquires the citizenship of another country, they automatically cease to be an Indian citizen.
Okay.
Or, if they acquired foreign citizenship before commencement, this disqualification prevents them from being considered a citizen under Articles 5, 6, or 8 in the first place.
So it works both ways, losing it or being prevented from getting it.
Exactly. India, at its constitutional commencement, made a very deliberate and firm choice. It did not permit dual citizenship.
Why was that choice made, do you think?
Well, it was a conscious decision, likely rooted in the desire to ensure an undivided, singular loyalty to the new nation, especially given the tumultuous circumstances of its birth, the partition, the competing claims. Clarity on allegiance was paramount.
The key word here seems to be voluntarily acquired.
It is. Very important. This isn't about someone being forced into another citizenship, perhaps by marriage laws or circumstances beyond their control. It's about a conscious, deliberate, knowing choice to embrace another nationality.
And that choice has immediate consequences for Indian citizenship.
Direct and immediate impacts under Articles 5, 6, and 8. For example, let's go back to Article 5. Someone who clearly qualified, maybe born and domiciled in India.
Okay.
But then, sometime before January 26, 1950, they actively and voluntarily went and obtained, say, British citizenship and got a British passport.
Right.
Due to Article 9, despite meeting the Article 5 conditions initially, they would definitively not be considered an Indian citizen at commencement. Their intentional act of acquiring foreign citizenship superseded their initial claim under Article 5.
So how was voluntary acquisition actually determined? Did getting a passport count?
That became the crucial question. And landmark cases like State of UP versus Shah Muhammad and also Izhar Ahmad Khan versus Union of India established a really key precedent.
Which was?
That the very act of obtaining and possessing a foreign passport was considered strong, almost conclusive evidence of having voluntarily acquired that country's citizenship.
Wow, so the passport itself was proof enough.
Generally, yes. It was seen as exercising the rights of a citizen of that other country. This principle, laid down very early on, established a clear legal boundary. It formed the basis for future laws on the termination of citizenship, drawing a firm line. Dual allegiance was simply not acceptable at the nation's birth.
It sounds like it connects to some older legal ideas.
It does. Article 9, in its essence, embodies that timeless legal principle, often expressed in Latin. Nemo potest, esse civis duorum patriarum.
Meaning?
No one can be a citizen of two fatherlands, or two homelands.
Yeah.
It directly ties into the broader doctrine of allegiance, the idea that citizenship implies an exclusive allegiance to a single state. Acquiring another citizenship, in this view, signals a transfer or a division of that fundamental allegiance, which Article 9 sought to absolutely prevent.
A very powerful statement about the exclusivity and seriousness of Indian citizenship.
As conceived by the framers, yes, very much so.
Okay, so we've covered Articles 5 through 9, who was a citizen at commencement, the partition complexities, the diaspora connection, and the bar on dual citizenship. But what happened after January 26, 1950? Did the rules just freeze?
Good question. No, they didn't freeze.
So you become a citizen under Articles 5, 6, 7's proviso, or 8. Does that status just last forever no matter what?
Not necessarily. And this brings us to the final two articles in Part 2, Articles 10 and 11. These are crucial because they ensure the dynamism, the ongoing evolution of citizenship law in India.
Dynamism. How?
They signal that the initial definitions in 5 through 8 are really just the beginning, and that ultimately, Parliament holds the power to shape the future of belonging.
Okay, let's take Article 10 first. What does that do?
Article 10 provides a crucial sort of overarching guarantee, or seems to, at first glance.
Oh, so?
It states that anyone who is or is deemed to be a citizen under any of the preceding articles, 5, 6, 7 proviso, 8, shall continue to be such a citizen.
Okay, that sounds like it locks things in. Stability.
Exactly. On the surface, it offers a powerful assurance of stability for all those initial citizens. It provides certainty about their newfound foundational status within the Republic.
But I sense a however coming.
There's a huge however, a vital caveat. This continuance is explicitly made subject to the provisions of any law that may be made by Parliament.
Ah, so Parliament can override this continuance.
Precisely. It means the right to continued citizenship, guaranteed by Article 10, isn't absolute or immutable. Parliament, the supreme legislative body, retains the inherent power to legislate on how citizenship is maintained, or indeed how it might be lost in the future.
So back to the Article 9 example.
Perfect example. A person becomes a citizen under Article 5 in 1950.
Sure.
Article 10 says they shall continue to be a citizen,
But
subject to laws made by Parliament. So if that person later, say 1960, voluntarily acquires foreign citizenship.
then Parliament's laws kick in.
Exactly. Their Indian citizenship could be terminated under subsequent laws made by Parliament, specifically the Comprehensive Citizenship Act that was passed in 1955. And that act, made under Parliament's power, would then affect the continuance promised in Article 10.
So it's a balance. Initial certainty, but ultimate legislative control.
A very dynamic balance, yes.
Okay, that leads us perfectly into Article 11, which you said gives Parliament sweeping power, almost overriding everything else.
That's right. Article 11 is where the Constitution truly ensures the living, breathing nature of citizenship law. It gives Parliament incredible adaptability. It grants Parliament what's called plenary power over citizenship.
Plenary, what does that mean exactly?
Plenary means full, complete, absolute, comprehensive legislative power over all aspects of citizenship.
All aspects, wow.
And the language used is incredibly powerful. It says, nothing in the foregoing provisions of this part, meaning Articles 5 to 10, shall derogate from the power of Parliament to make any provision with respect to the acquisition and termination of citizenship and all other matters relating to citizenship.
Nothing shall derogate from the power of Parliament. That sounds strong.
It's what lawyers call a non-derogation clause. It emphatically ensures that Articles 5 through 10, which were primarily focused on defining citizenship at the moment of commencement, do not in any way limit or detract from Parliament's future legislative competence in this area.
So Parliament isn't constrained by those initial 1950 rules.
Not at all. It's supremely empowered to build upon them, to amend them, to craft entirely new laws about citizenship as the nation evolves and its needs change.
And the scope of this power under Article 11, you said all matters. How broad is that?
Breathtakingly broad. Parliament can make laws regarding the acquisition of citizenship, how people become citizens after 1950. It can make laws regarding its termination, how citizenship might be lost. And crucially, that catch-all phrase, all other matters relating to citizenship.
That covers pretty much everything imaginable.
It really does. It covers every conceivable aspect of who is a citizen, how they become one, how they might cease to be one. It transforms those foundational principles we discussed in Articles 5 to 9 into a truly living, adaptable legal framework.
So this Article 11 is the basis for modern citizenship law in India.
It is the absolute constitutional bedrock. It's the foundation for India's Comprehensive Citizenship Act, 1955, and all of its numerous subsequent amendments over the decades.
And that act is where we find the current rules.
Yes, that's where Parliament lays out the contemporary pathways for people to become citizens today. Things like citizenship by birth, the rules for that have changed over time. Citizenship by descent, for those born abroad to Indian parents. Citizenship through registration for specific categories like spouses of citizens or people of Indian origin. Citizenship by naturalization for foreign nationals who meet residency and other criteria. And even citizenship by the incorporation of new territory into India.
And also how you can lose citizenship.
Yes, the 1955 Act, empowered by Article 11, also details how citizenship can be lost. Through voluntary renunciation by the individual, through termination by the government. For instance, if someone voluntarily acquires foreign citizenship, linking back to the principle in Article 9, or through deprivation in certain specific circumstances, like obtaining citizenship by fraud.
So even things like the OCI scheme.
Overseas Citizenship of India, yes. Even innovative schemes like OCI, which grants specific lifelong rights and privileges to persons of Indian origin who are foreign citizens without granting them full political citizenship.
Right, they can't vote, for example.
Exactly. Even that scheme derives its legal authority directly from laws Parliament made under the expansive powers granted by Article 11. It shows the flexibility Parliament has.
Now, this power of Parliament under Article 11, it's obviously very relevant today. Thinking about recent changes to citizenship law.
It is highly relevant.
Yeah.
And it raises an important contemporary point. Recent amendments to the Citizenship Act, such as the Citizenship Amendment Act, 2019, often called the CAA.
Yeah.
That amendment was also passed by Parliament, explicitly invoking its powers under Article 11.
Okay.
Now, the constitutional validity of that particular amendment has, as many listeners will know, been challenged in the Supreme Court.
On what grounds?
On various grounds, but primarily based on arguments that it potentially violates fundamental rights guaranteed elsewhere in the Constitution, particularly Article 14, which guarantees the right to equality before the law.
So Parliament's power under Article 11 isn't completely unlimited.
Exactly. This ongoing situation highlights the dynamic interplay between Parliament's vast legislative power under Article 11 and other overarching constitutional principles and fundamental rights. It demonstrates that even this plenary power isn't absolute. It must always operate within the larger framework of the Constitution, especially when it concerns fundamental rights and the core principles of justice and equality that underpin the entire document.
So Articles 10 and 11 together,
Yeah.
what's the big picture takeaway?
Taken together, they firmly establish what's often called the plenary legislative power of Parliament over citizenship. They embody a form of the doctrine of parliamentary supremacy in this specific domain. And it's a crucial, but always subject to the Constitution's basic structure and its guaranteed fundamental rights.
Okay. So we've journeyed through Articles 5 to 11. We've looked at the definitions, the exceptions, the evolution. What does all this mean for you, the listener, trying to grasp India's identity through its laws?
Well, as we've taken this deep dive, peeling back the layers, what emerges isn't just a dry set of legal rules, is it?
No, it feels much more alive than that.
It's a remarkably coherent, incredibly thoughtful, and as we just saw, highly dynamic framework for defining national belonging. It really stands as a testament to the profound foresight and adaptability of India's founders.
The foresight seems key. They were dealing with immediate chaos, but also thinking long term.
Absolutely. That's what's truly fascinating and, frankly, deeply impressive. They weren't just reacting. They simultaneously addressed the immediate traumatic realities of partition, trying to account for millions displaced and bewildered, while also building a robust, adaptable system designed to last for generations.
Balancing present needs and future possibilities.
Precisely. They skillfully balanced the urgent need for inclusiveness right at the start with essential mechanisms for national security and order, like that careful permit system in Article 7 for returnees. And they laid down the absolute clarity of single citizenship in Article 9.
They understood the link between citizenship and identity.
Profoundly. They understood that a nation's identity is intrinsically, inextricably linked to who its citizens are and how that status is defined, bestowed, and protected.
And the enduring power, then, of Articles 10 and 11. That's the living part.
That is the truly living aspect, yes.
Yeah.
Is precisely that they allow the law of citizenship to continually evolve. This isn't a static document, rigidly fixed in 1950, forever bound by the circumstances of that time.
It can adapt.
It can adapt. It's a living legal scaffolding that Parliament can amend and adjust to meet the nation's changing needs. Whether that's dealing with the growing global diaspora, managing new patterns of immigration, responding to unforeseen geopolitical shifts, or addressing evolving social realities. These articles ensure the Constitution remains relevant, responsive, and robust through the decades.
So understanding these foundational articles, it's more than just law.
Oh, far more.
Yeah.
If you connect this to the bigger picture, understanding these foundational articles gives you much more than just legal knowledge. It offers you a profound insight into the very essence of a nation's identity.
How it defines itself.
Yes, its deepest relationship with its people. And the ongoing, vital, sometimes contentious dialogue about who belongs and how that belonging is formally recognized by the state. It fundamentally shows how legal frameworks like this are meticulously designed. They aim to be both foundational, providing that unshakable starting point, and simultaneously flexible, allowing for necessary adaptation and evolution in response to the ceaseless currents of history.
A blueprint for belonging.
A blueprint for national belonging, yes. One that continues to shape the contours of modern India and its place in the world today.
So to wrap up, we've journeyed together through these crucial constitutional provisions, Articles 5 through 11, defining Indian citizenship right from the start.
From who was counted at independence,
to how the framers tried to manage the overwhelming human impact of partition.
and ultimately how they empowered Parliament to shape the future of belonging for generations to come.
It's a complex picture, but hopefully an insightful one. A look into the intricate legal process by which a nation defines itself and its people.
And this deep dive, in turn, it really raises an important, maybe even provocative question for you, the listener, to think about long after this conversation ends. How does any nation, not just India, but any nation, truly balance its historical obligations to its people, especially those displaced by conflict or those living abroad with strong ties? How does it balance those obligations with its evolving geopolitical realities, its national security interests, its economic needs, when it defines and redefines citizenship over time?
That's a tough balancing act.
It is. And given Parliament's vast, undeniable powers under Article 11 in the Indian context, what profound implications might that have for future definitions of who truly belongs to the ongoing, unfolding Indian story?
These aren't just dry legal questions, are they?
No, they're deeply human ones. Questions about identity, belonging, fairness, history. They resonate through time.
Well, this deep dive has hopefully given everyone listening a solid, comprehensive foundation.
We hope so.
And if your curiosity has been piqued, if you're eager to explore further,
Then we'd highly recommend delving into the various amendments made to that key piece of legislation, the Citizenship Act of 1955, over the years.
see how the law has actually changed.
Exactly. And perhaps even look into some of the contemporary debates, the landmark court challenges surrounding citizenship today.
Because the conversation is always evolving.
Always dynamic. And now, hopefully, you have the constitutional toolkit to understand its profound depths and complexities.
Absolutely. Well, thank you for joining us on this deep dive.
Thank you.
Until next time, keep learning, keep questioning, and keep exploring.